Good morning, everyone, and welcome to our webinar, Structural Failure, Getting Business Structures Right, which is proudly supported by Folbigg Lawyers, our esteemed and long-standing platinum partners. I'm thrilled to see such a fantastic turnout online, and I'm confident that today's webinar will provide you with a wealth of valuable insights. My name is Adam Phillips. I'm serving as Treasurer and a member of the board at Western Sydney Business Connection. Before we begin, I acknowledge that I'm hosting and recording this webinar from the lands of the Darug people. I also acknowledge the traditional custodians of the various lands on which you all work today and the Aboriginal and Torres Strait Islander people participating in this webinar. The Connection is proud to be partnering with 6 incredible businesses to ensure you continue to have access to webinars like the one today at little or no cost. I'd like to thank Folbigg Lawyers, Campbelltown City Council, Commonwealth Bank, Hitachi, Parramatta Leagues Club, and World Class Teams. Today's webinar will be presented by Geeti Chawla and Zeeshaan Nordien, both principals in Folbigg Lawyers Commercial and Corporate Law Group. Geeti advises clients on a broad range of commercial, corporate, and property law matters, and has assisted startups, emerging and established businesses, including assisting them with restructuring and transitioning enterprises and wealth from one generation to the next. Zeeshaan provides strategic counsel across an array of commercial and corporate areas, encompassing commercial agreements, corporate structuring, business acquisitions and sales, as well as legal due diligence. I'm delighted to welcome our presenters for today, Geeti and Zeeshaan. Over to you.
Thanks for that introduction, Adam. As Adam mentioned, Zeeshaan and I will be presenting today on the topic of getting business structures right and the importance of the right business structure. Irrespective of what stage your business is in or the type of business you operate, it is critical to have the right business structure in place. There are several reasons for getting business structures right, particularly to ensure asset protection, minimizing risks, and ultimately to optimize returns. The process of business structuring, particularly for the purpose of asset protection, essentially involves minimizing the exposure to risks of losing personal and business assets. Asset protection, both in a personal and business context, should be a constant and adaptable process, reacting whenever necessary to change to the circumstances of both the business and individuals, as well as the environment around them. Ideally, it should give the ability to control or have access to assets that a person does not legally own in an effort to prevent that person from losing those assets. However, in reality, the process of business structuring and asset protection is often an incremental one, where steps consistently need to be taken to bring the structure up to date from time to time. Most of you would appreciate that each business structure has its own assets, own risks and benefits. They also each have their own unique criteria, compliance, regulatory requirements. It is therefore important to carefully consider these and obtain the necessary legal, financial, and tax advice before adopting a particular business structure to ensure that it is the right structure that meets both your business and personal needs. The most common business structures are these 4 here: sole trader, partnership, company, and trust. We've all heard of those. There's also other structures, self-managed super funds and joint ventures, but we won't be delving into those today. This table from ASIC, which is just a general guide of these 4 main business structures that I've just mentioned, sets out the complexity of each of these structures, the costs and legal obligations associated with these structures, whether or not the structure provides a separate legal entity, and finally, the exposure to liability under each of these structures. Again, it's just a guide. So briefly, and as you can see, sole trader and partnerships are generally regarded as simple and less complex structures. They're also quite easy and inexpensive to set up and maintain. A sole trader structure involves an individual operating the business in their own name, in their personal capacity, with minimal compliance requirements and absolute control of assets by that sole trader. However, a sole trader has exposure to unlimited personal liability and little to no asset protection. On the other hand, a partnership structure is between 2 or more parties who share liabilities. Similar to sole traders, partnership structures have minimal compliance requirements, medium to low maintenance costs involved. Again, and similar to sole traders, partnership structures have minimal avenues for asset protection. This is essentially because partnerships do not involve having a separate legal entity, and generally partners are jointly and severally liable in their respective personal capacities. There are, however, three different types of partnerships. There's general, limited, and incorporated limited partnerships. Other than an incorporated limited partnership, each partner under a general or limited partnership structure is jointly liable with the other partners. But partnerships can be set up in a way where partners are corporate entities or trusts with corporate trustees in order to keep the benefits of a partnership structure with limited liability. And Zeeshaan will delve into that a little bit more later. Unlike sole traders and partnerships, a company structure involves a company which is incorporated and governed under the Corporations Act as its own separate legal entity, distinct from its owners or shareholders and directors who manage the affairs of the company. Generally, companies can be structured in a manner that is consistent with the nature of the business and its industry, the intended number of shareholders and office holders, the business plan, and the business annual turnover and profit, amongst many other things. A company is either a public company or a private company, and within those, a private company can have its liability limited by shares or by guarantee, unlimited liability or no liability. On the other hand, a private company is either limited by liability by shares or unlimited liability. An attractive benefit of adopting a company structure, as I mentioned earlier, is that it is a separate legal entity. And in that capacity, a company is capable of owning assets and incurring liabilities independent from its shareholders and directors. A company in its own capacity is also able to commence legal proceedings as well as be sued. There are several advantages and disadvantages of the company structure. Some of these include shareholders of a company generally have limited liability. This means that they're not in their personal capacity liable for the debts of the company, where the debts of the company are limited to the company's assets. But this is, of course, provided that the company does not trade insolvent and otherwise does not breach the Corporations Act. As companies are able to own assets in their own right, ownership of those assets is distinct from the assets of its shareholders. But this is provided, again, that a shareholder is not a director of the company or that shareholder has not provided personal guarantees. Directors of the company have an ongoing obligation to prevent insolvent trading of the company pursuant to the Corporations Act, which basically means that directors may be at risk of being held personally liable for the company's debts and having their personal assets exposed. These risks are further amplified where directors and shareholders have provided personal guarantees, whether it is a personal liability of directors prescribed under the Corporations Act or any personal guarantees provided by directors or shareholders. Such personal guarantees can survive the winding up or deregistration of the company, which means that it can be an ongoing risk. Similar to companies, setting up trusts involve forming a legal relationship where the trustee, which can either be an individual or corporate trustee, legally holds assets or property on trust and ultimately for the benefit of the beneficiaries of the trust. There are many types of trusts used in Australia. These include discretionary trusts, family trusts, unit trusts, hybrid, bare trusts, and many more. Each type of trust has its unique features, and choosing the right trust structure is effectively dependent on the individual or business needs. Where a trust is required for business or investment purposes, often trust structures that allow maximizing wealth accumulation and asset protection are preferred. In our experience, and for those reasons, discretionary and family trusts and unit trusts are the popular choices. So very briefly, discretionary and family trusts are commonly used by families and smaller family businesses where the trustee has the power to allocate such of the trust capital and income to such of the beneficiaries as the trustee in its discretion considers appropriate. On the other hand, unit trust involves the beneficiaries of the trust to hold a certain number of units in trust, known as unit holders, that are transferable subject to the terms of the unit trust, similar to shares held in a company by its shareholders. Unlike companies, a trust is not a separate legal entity, and therefore the trustee is liable for all of the liabilities of the trust, which is an apparent risk that is often circumvented with setting up trusts with corporate trustees instead of individual trustees. I will hand it over to Zeeshaan, who will talk in more details about the intricacies of these structures.
Thank you, Geeti. Morning, everyone. I'll be looking at these structures in the context of asset protection and how they work practically. As you know, asset protection challenges are commonly experienced by sole traders and partnerships due to the disadvantages and the reasons that Geeti mentioned just a bit earlier. These challenges are primarily due to the business and the individual sharing that same legal personality. So there's no separation of personality. What this does is it leaves the personal assets vulnerable to the business risks and also exposes the business assets to the claims that may arise against those individuals personally. So one needs to consider what are the consequences of this sort of structuring, which we call poor structuring. Well, it occurs more often than one may think that people are faced with losing personal assets as a result of unsuccessful business ventures. So your personal wealth, such as family homes, personal investments, savings, and numerous other things, are exposed to claims arising from business debts. And that's due to poor planning, lack of due diligence, and simply failure to implement a suitable business structure. Conversely, and for similar reasons, we also see business assets being exposed to personal claims brought against individuals. And those claims brought against you personally also can take various forms. It could be personal debts, it could be family law claims, it could be damages claims, a number of claims. So you of course want to protect your business interests against those kind of claims. And although, as Geeti mentioned, the company may have limited liability, bear in mind that if you own the shares in that company in your individual name, those shares would in fact constitute an asset in your personal estate. And because it's an asset, it's a tangible asset, they can be subject to claims of your personal creditors. So it's for this reason, when we consider structuring, we say to ourselves that your structure must also aim to protect your shares, so your business interests, against any claims that arise against you personally. Now, failed businesses, financial problems, legal challenges, they're not always within your control. They can be caused by circumstances way beyond your control. And I think that the recent pandemic is a typical example that we are all quite familiar with, where there were consequences just out of our control. So if you are in business, it's really important that you implement a structure that will offer you protection from both angles. Now, the appropriate business structures will vary from one person to another. There's no one-size-fits-all scenario. It'll depend on your circumstances. So it'll depend on what are your objectives, what are your business interests, do you have more than one business interest, what is your financial position, what are your personal assets, and all those sort of other factors that one would need to consider. So what I'll do is I'll just briefly explore some of the common structures that we advise on to our clients from time to time. I just wanted to say that it is prudent that you always obtain financial and taxation advice with the appropriate from the appropriate professionals. So take into account the tax implications. And often we find when clients are considering tax implications, we've got to create that balance between the tax implications and the asset protection benefits. So that's something always to be mindful of. I'm just going to pull up a little diagram we put together. So just a simple diagram to explain one of the more common structures that we advise on. So in this scenario, it's two parties, they've got two businesses. So this structure would work if you've got two or more businesses, for instance. And we say to you, look, let's put a structure in place where you've got a holding entity and you've got several trading entities. So let's say, for example, you've got one business that's in financial services, one that owns a food services business, and one in another business. All those businesses have various levels of risk in those various industries. So by creating a structure where you've got a holding entity in these three separate trading companies that we've got over here, it means that each business will operate independently. And by using separate trading entities for each of these, one entity will be protected from the business risks from the other entity. So if one business is unsuccessful or faces any sort of failure, it's easier for you to sever ties with that business without impacting on the operations of your other businesses. So implementing the proper structure in this scenario can ultimately protect the successful business from any claims that arise against a failing business. Another example that I've got on the screen over there is, again, we've got two shareholders that decided to create a company. And in this scenario, again, we're advising on, let's create a holding entity to house your interests in whatever ventures you have going forward. But in this scenario, we've got a company that has significant assets. Some of them, they're largely unencumbered assets. So let's say you've got property, plant, equipment, or even intellectual property rights that are of immense value, and you don't want to expose those assets to the claims of any trade creditors, for example. We'd say, let's create an asset holding entity to hold all those assets of value, and let's create a separate entity for you to trade with. So your trading entity would be the entity that's entering into contracts with your suppliers, your creditors, etc. And of course, you'd have the necessary arrangement between these two entities, whether it's leases, licenses, or whatever other relevant documents are required between the respective entities to govern that relationship. Then the next one that we've got on the screen, it's quite a common structure that we advise on, and this is a simple structure where we get approached by two or more parties. They'd like to start a new business, and we'd say to them, look, a good framework that we think would work for you would be, let's create a discretionary trust for each of you. Each of you would be a principal beneficiary of that discretionary trust, and that discretionary trust would ultimately house your shares. We'd incorporate a limited liability company, so the company that Geeti spoke about a little bit earlier. And that limited liability company would be what's referred to as the trading company on the slide. And that would be your trading entity. Each party then would appoint a director to act for them, and their shares or the interest in that company will be allocated to their respective discretionary trusts. So where a company involves two or more parties, it's essential to implement the necessary internal measures as well, because you want to protect the business from caving. You want to protect it from instances where there's a relationship breakdown, a dispute between the shareholders, the directors, or even you want to protect yourselves against the death, incapacity, or bankruptcy of a party. So I'm going to hand over to Geeti again to discuss the importance of corporate governance in this instance.
Thanks, Zeeshaan. Talking about a company structure would be incomplete without discussing the importance of corporate governance, and as such, the importance of a well-drafted company constitution and a shareholders' agreement if there's two or more shareholders in a company. A company constitution, together with its shareholders' agreement, provides the foundation for corporate governance. Each of these documents operates in conjunction with the other. They're different documents with different features, where a shareholders' agreement governs the relationship between a company and its shareholders. A company constitution governs the internal operation and management of the company. Having poorly drafted documents, and in some cases even the off-the-shelf ones, can expose the company along with its directors and shareholders to unforeseeable risk. Especially when it comes to a shareholders' agreement, we do not recommend the one-size-fits-all approach, because it fails to deal with a range of matters that should otherwise be specifically dealt with in a tailor-made shareholders' agreement. Similarly, a company constitution should be tailored to the specific needs and requirements of the company. I'll just go to the next slide, which basically shows what a well-drafted company constitution and shareholders' agreement should consider having these features depending on the individual needs of the companies, its shareholders and directors. I'll go through some of these. So the first one I'll go through is the company management, where these documents should consider the structure, management and direction of the business, and also the division of responsibilities between the directors and shareholders. Decision-making, another critical point, where the matters or affairs of the company are dealt with by both the directors and shareholders, each with their own respective decision-making powers. And often these are specifically set out in the shareholders' agreement, customized to the specific needs of the company. Decision-making, often you might have heard, can be by way of ordinary resolution of directors and shareholders. So ordinary resolutions are usually passed with more than 50% votes, whereas a special resolution of directors and shareholders is usually passed with more than 75% votes, but this can change. Transfer of existing shares in the company and issuing of new shares, which essentially deals with the acquisition and disposal of existing shares in the company, as well as issuing a subscription of new shares in the company. Preemptive rights, which is associated with both of these, so it could be the transfer of existing shares and issuing of new shares, which is essentially the existing shareholders' first right of refusal or option to purchase the shares on offer before these shares are offered, either the existing ones or the new ones, to the third parties. Restraint of trade prevents parties from soliciting clients of the company, owning or working for a competitor company, and also involves other non-compete provisions that can be customized to your needs. Funding can include rules about maintaining sufficient working capital to conduct the business of the company, including raising capital by way of loans from shareholders and directors. There's also drag-along and tag-along rights. Drag-along rights included in the agreement ensure that if agreement, it is agreed by majority of the shareholders that there is an intention to sell shares to the same third-party buyer, then the remaining shareholders will be required to also sell to that their shareholding to that third-party buyer. In contrast, tag-along rights included in the agreement ensure that there is a third-party buyer often offers to buy a shareholder's shares. That shareholder must notify all the other shareholders and offer the other shareholders an opportunity to sell their shares to that third-party buyer at that tag-along offer price. Dispute resolution is also an important provision which should ideally set out the provision for resolving disputes, perhaps through negotiation and mediation in the first instance, failing which, in a deadlock situation, sometimes the disgruntled shareholder may be forced to offer their shares to the other shareholders. This is the infamous Packer clause. Share valuation, again, another key aspect which sets out the process to determine the fair market value of the shares of the company, considering a wide range of factors, such as the standard principles applied to determine the share value and the current financial position of the company, usually by engaging an independent valuer to determine the value of each share. Insurance, another important one, sometimes often left out of shareholders' agreement, which should essentially set out the requirements to take out and maintain necessary insurance policies in respect of all risks for the conduct of the business similar to that particular company in that industry. Of course, this is just a guide, and the advice to prepare these documents will vary from company to company. These are only some of the many considerations and factors that should be taken into account when thinking about drafting a company constitution and shareholders agreement. And that's directly contingent on the company, its business, and the needs of its shareholders and directors, and in some cases, its employees. I'll pass it back to Zeeshaan to talk about our last business structure, which is trusts and the asset protection in that context.
Thanks, Geeti. Let's go back to that previous slide for a minute. As Geeti mentioned in the introduction, a company is capable of owning assets and incurring liabilities of its own, so independent from its shareholders and directors. Therefore, if a company enters into contracts with suppliers or creditors, financial institutions, etc., those suppliers or creditors would generally have recourse against the company and its assets in the case of default by that company. But they wouldn't necessarily have a claim against the personal assets of the directors and shareholders. However, as we know, it's become common in commercial practice for business creditors, banks, landlords, and all other parties under contract to request personal guarantees from directors. And in some instances, these guarantees are also requested from shareholders. For directors, that personal liability extends a bit further. There's personal liability for the company's debts and obligations that arise from various instances, whether it's statutory duties under the Corporations Act, whether it's their duty to prevent insolvency under the company, whether it's directors' penalties issued for ATO debts such as PAYG or superannuation guarantees. So we need to be mindful of the exposure that you could have both under the guarantees and under these instances for shareholders and directors. So it's important to protect your personal wealth against these risks. Ideally, then, we say you shouldn't hold your assets in your personal name if you want to protect it against these risks. So in the scenario that we had on the slide that's up at your screen, you would have seen we said, let's create a corporate trustee for you to house your interest in the company, which I'll talk about a bit later. But what we're talking about here is creating let's call it a family discretionary trust that would suggest that you create to acquire and hold assets, so your personal assets. And those assets then will not form part of your individual estate. They will not be exposed to claims that arise against you personally as the shareholder or director of the company. As the trustee, you'll be able to exercise control over those assets, which is great. As a beneficiary, you'll be entitled to the use and enjoyment of those assets. And you wouldn't actually need to legally own those assets. So you'll just be entitled to the benefit of it. And as an appointer of that trust, you'll have the power to appoint and remove trustees. So there's that level of ultimate power that sits with you as well if it's properly structured. Now, for a discretionary trust to work, obviously needs to be properly constituted. Your deed needs to be properly drafted, and it needs to be properly discretionary. At this stage, I'll just note that if you already own any assets, please be mindful that the transfer of those assets can have tax implications, it can have duty implications, and some legal implications. So don't just go ahead and transfer assets right now. It's important that you seek professional advice before doing so. So speak to your lawyer, speak to your accountant, and see whether that asset transfer is going to have any implications of concern for you. Going back to our slide, the trust that we've got referred to over there, we've got under shareholder 1 and shareholder 2. I'll refer to those as business trusts. And over there, given the potential exposure of a shareholder, we recommend that you create separate discretionary trusts to hold your shares in your company. You wouldn't want to hold your shares in your family trust because we wouldn't want your family trust to be exposed to the claims of those shareholder guarantees in the instances we spoke about earlier, because that would just undermine the very purpose of asset protection and having your family trust in place as your nest egg in the first place. So if your shares are held by a discretionary trust, you'll similarly not legally own them, as in the scenario I mentioned with regards to the family trust. This means that if you are sued personally, your shares in the company, in this example over here, because you don't own them yourself, will not be exposed to claims that are brought against you personally. Now, in this slide, you'll also see where we talk about the discretionary trusts, I refer to something called a corporate trustee, which Geeti also mentioned at the beginning, and I'm sure some of you are familiar with. Now, while a trustee has a right of indemnity against the trust, a trustee can be personally liable for the debts of the trust in the case that the trust doesn't have assets or in the case that the trust doesn't have sufficient assets. So as a protection against this risk that could be faced by a trustee acting in his or her personal capacity, it is recommended that you appoint a corporate trustee. Now, a corporate trustee is simply a company that acts as a trustee. The company that's used for this purpose, our advice would be, should be used for this purpose and this purpose only, and that company shouldn't own any assets. And the reason for this is that the liability then of that company would be limited only to its share capital. What should be borne in mind, though, is that there are instances where a director of a corporate trustee could be accountable. So the director of a corporate trustee should be mindful of that potential liability under the Corporations Act, and it's dealt with under Section 197. And there are instances that's outlined in that section where a director rather of a corporate trustee cannot be fully indemnified, because it says in instances where there's been a breach of trust by the corporation, if the corporation is acting outside the scope of its powers as a trustee. And in those instances, for example, you, as a director of the corporate trustee, could be personally accountable. So in conclusion, to say it's important for businesses to ensure that they have adopted the right structure for their business to, amongst other things, maximize asset protection and minimize tax implications and to limit liability. It's always important to obtain the necessary financial, taxation advice and legal advice when you're considering structuring. You may currently have a business structure that might not be right for you, limiting your ability to maximize on the benefits available under other business structures. In that case, you might want to consider restructuring your business to reap the benefits through a structure that is more appropriate for you and for your business. Irrespective of the business structure, it's essential for businesses to initially assess both benefits and risks associated with any business structure. Now, what we've done is we've prepared a brief checklist that might help you just to identify any structuring flaws or any areas in your business structure that might require attention. So if you do need, if you'd like to get a copy of that checklist, you're welcome to either email Geeti or myself, and we'd be happy to share that with you. At this stage, I'd like to say thank you and hand it back over to Adam.
Thank you, Geeti and Zeeshaan, for such an informative presentation. If anyone has anything they would like to ask Geeti and Zeeshaan, please enter it in the Q&A box below. But whilst we're waiting for that, for questions to come through, I'd like to take the opportunity to let you know about our upcoming Breakfast Masterclass, Unshaken Leadership, Empowering Your Organisation to Thrive in Turbulent Economic Times. That's being held on Wednesday, the 23rd of August in Parramatta. This Breakfast Masterclass will equip you with the tools to empower leaders at all levels of your organisation and enable you to not only survive, but thrive in uncertain times. For further information, you can go to our website, wsbc.org.au. Okay, so in terms of any questions, I've got one here that's come through at the moment. Just let me bring that one up. There was a Commonwealth Budget proposal re-tax exemptions regarding SME restructuring. Would you like to answer that one?
What was that question, Adam?
There was a Commonwealth Budget proposal regarding tax exemptions for SME restructuring.
You want to take it? I think that's more of a tax question than it is a legal one. So I'd probably recommend that they speak to a taxation lawyer or an accountant with regards to taxation exemptions rather than us.
Yep. Okay. There's no other ones at the moment. I have just a general question. What do you see as the most common go-to structure for a trading business?
It would depend on the trading business. So if you looked at the last slide that I put up, would be a common one that we see amongst small businesses. You know, where you've got a PTY Ltd trading company, and you've got a structure with 2 or more shareholders, and their interests in that structure are housed by a discretionary trust. And of course, you've got your shareholders agreement, which governs the relationship between those 2 shareholders, and then your overarching constitution, which governs the company generally. So I'd say that the one on the slide right now would probably be one of the more common ones, especially amongst your smaller businesses, where they, you know, where they're conducting one type of business only.
Yep. Okay. And just before there's one more question that's come through, but before, on a similar kind of note, early in your structure, you had the holding slide, you had a holding company, and then 2 companies below that. One was a trading company and one was an asset holding company.
Is it that one?
Yep, that's the one.
Yes.
The advantage of having, can you explain the advantage of having a separate asset holding company below the holding company rather than having the assets in the holding company itself?
Well, the reason for it is your holding company is holding your interests in both entities, right? So that sits the base of your structure. So it holds everybody's interests. And you don't want to be trading in your holding company, because your holding company, the very reason for having the holding company is to have the shared interests of shareholder 1 and shareholder 2 in that scenario. So your holding company is not the company you want to use for trading, because you don't want your holding company either to be exposed to the liabilities or the risks associated with that trading. And it's for that reason you're creating these 2 separate legal personalities specifically. So one would be trading and one would be asset holding. And in this example, your asset holding company won't be exposed then to the liabilities and risks of your trading company.
Yeah. So having the assets up in the holding company, obviously having a subsidiary is the risks of that trading company below it become at risk. Yep. Joseph's asked, can you touch on SMSFs at all?
What is the like? Look, SMSFs, it's self-managed super funds. They are a rather specialized field, you know, that involves financial advice. Are there specific questions you have, Joseph, regarding SMSFs? I mean, in general, I can say to you, an SMSF is created with a trust structure based on a trust deed. It's a self-managed super fund. And it operates where you've got a trustee that operates that SMSF. And in most instances, that trustee would also be a corporate trustee. So a very similar structure, but the trust isn't necessarily as discretionary, because SMSFs, as we know, are a very regulated industry. So there's some rules and statutory compliance issues that one needs to take into account when drafting that deed of trust for the superannuation fund. And, you know, with an SMSF, of course, your beneficiaries, there's also restrictions on how you can define your beneficiaries, etc. Are there any specific questions or concerns you have, Joseph, regarding an SMSF?
he's put through in the chat there, are they a good idea? I'd suggest that it depends on the situation of whether they're a good idea or not. It's saying access to profits. Would you like to answer that one? Or I can answer that one as well if you want. Given an SMSF is a superannuation structure, it depends on your circumstances, but you're reminded that access to profits, you can't access those until you've met a condition of release and potentially in retirement. And if we're talking about investments, I don't want to get into obviously running a business and things through an SMSF. That's a whole other topic, but SMSFs are very specific to people's needs.
Yeah, look, we do see clients using SMSFs for investment purposes, subject to complying with the rules, or for lending scenarios, subject to what their trust deeds allow and don't allow. So, I mean, the answer is yes, it can be used, but it's got rules, regulations, and restrictions, and it's always going to be important that you get the proper financial advice before even venturing down that avenue.
Yep. Got a few other questions here. What general recommendations and procedures do you have to limit holding company liability?
Yeah, look, by its very nature, a limited liability company has limited liability, right? And by employing one of these structures, you'd be protecting yourself against various risks. So on that question, I'd probably ask you, what sort of risks would you be concerned about? What sort of liabilities do you want to protect against? So, we can explore that a bit further.
Another question come through from Vinoth. In any specific recommended structures for a real estate business?
Yeah.
Ideal structure.
Yeah, look, it depends. If you don't have partners and it's just you and you're operating a real estate business, subject to, as you'd know, there's legislation that governs real estate generally. But yeah, I think a simple structure would be fine if you were a single owner. So your trading company, no partners involved. So if there's no partners involved, you don't necessarily need to implement a shareholders agreement just then. It's a good idea to have your constitution in place at the time you create the company. You as the licensed real estate agent would be the director of that entity, I'm sure. Obviously, there's all sorts of insurances you need in place to protect you from liability aside from your asset protection structure. Your shares in that company would be held, in the example we gave you a bit earlier, would be held in a business trust, for instance, so a discretionary trust to house your business interests. And then, of course, we'd say to you, let's create a separate trust alongside where you're going to house your family interests or your personal interests. And I guess in real estate, you could expose yourself to all sorts of implications. You could have a client that's disgruntled and your insurance is not enough, and someone sues you for that. So you don't want to expose your personal assets to that sort of claim. So how's your interests in that discretionary trust? And similarly, how's your interest in the real estate in its own trust? So that if someone does sue you personally, the wealth that you're building in that real estate entity is not going to be exposed. And remember, just because you don't incur liabilities in your personal name doesn't mean you're not going to have a claim against you. You could be sued for bumping someone over in the street and you don't want to lose your shares in that company. So yeah, I'd say a simple structure to that effect would work if you were a sole operator and you're looking at building assets and preserving those assets for your family.
Thank you. On a similar topic in terms of a structure on a specific industry, how would you suggest a GP on contracts set things up?
Sorry?
A GP, sorry.
Yeah, GP.
A general practitioner.
Yep.
Again, I think that's be similar. I would imagine you would have certain trusts in place and have a holding company with corporate trustees involved. So I'd imagine it'd be a similar structure. Again, with GPs or any medical profession, there's rules and regulations similar to real estate agents. So you'd be mindful of those. It would really depend on various factors and where you're setting up the GP, who are you setting it up with, who's going to be the directors, who's going to be the shareholders. the split between those. A few times we've seen, and we haven't talked about it here, but we've seen joint venture agreements where there's an external party who's not a general practitioner or a medical background, so there'll be a joint venture structure there. It really is really variable.
Thank you. I've got a question in probably or that relates to the shareholders agreement. Can the valuation of shares be left to the discretion of a director upon termination of an employment of a shareholder? Or does this fall under the governance of the shareholder agreement of the company?
Ideally, it should fall within what the shareholders agreement says, but often we've found that there is, these things can be silent. If it's a well-drafted shareholders agreement, it would have some sort of a share valuation mechanism there. If you don't have that, I mean, you can, of course, offer your shares for a certain amount, and it's really up to the others to buy it, but you kind of also potentially are exposing yourself to disputes in the future that, what valuable consideration did you get for those shares on those transfers? So ideally, we would always recommend that you actually get a share valuation. You value your business, you value each share, and that's the value that you stick with.
Circling back to the holding company scenario, how do you protect holding companies for insolvent trading claims and liabilities arising through trading companies? So I'm assuming that's the subsidiaries that would be trading insolvent. So how do you protect the holding companies?
Yeah, look, I guess from the director's perspective, they've got the obligations to comply with under the Corporations Act to avoid insolvent trading generally. With regards to the protection of the holding company, if the holding company owns the shares in that subsidiary, you don't want that holding company to be signing any sort of cross guarantees and that sort of thing for the trading entities. Otherwise, it's going to be exposed to it. As the holding entity generally, though, it's going to be looking at your contractual relationship with those suppliers as to whether there's going to be any liability that arises. So I guess it's going to be about, if you're implementing your plan to get these companies started and trading, to just make sure that you've got the necessary agreements in place, that you haven't overexposed that holding entity, and of course put some indemnities in place between the two entities.
Thank you. That looks like all the questions we have for now.
Look, if you have any further questions that you might think of after this webinar, our details are up there. Please feel free to contact us, email us, whatever's easier. And like Zeeshaan mentioned, we're happy to send you a checklist for you to just go through and see if you tick off all those boxes. And if you do or you don't, it just opens up a channel for you to talk to us further.
Thank you. Well, that concludes our session for today. Thank you, Geeti and Zeeshaan, for your time.
Thank you.
And Matthew's Folbigg Lawyers for supporting this webinar. Finally, I'd also like to thank our members and guests for your attendance today and your ongoing support. Have a great afternoon. Thank you, everyone.
Thank you.
Thank you.